Let's take a quick look at the steps of a typical criminal case. Most criminal cases begin with an arrest by local law enforcement officers who take the suspect into custody, search for weapons and contraband, and transport the suspect to the station.
They then refer the case to either the district attorney or the city attorney, depending on the location of the arrest and what type of crime was committed. After reviewing the evidence, if the prosecuting agency decides that a crime has been committed, the prosecutor determines what charges should be filed.
At that point, a criminal complaint accusing the defendant of committing the crime is filed in the Superior Court. The complaint is prepared in the name of the people against the defendant. As the people's representative, the prosecutor's responsibility is to uphold the law and ensure that only the guilty are convicted according to the law.
After the complaint is filed, the first court proceeding is an arraignment. This is where defendants are advised of their constitutional rights, hear the charges against them, plead guilty or not guilty, and where the initial bail is set. The public defender or other defense counsel may be appointed by the court to represent a defendant who is indigent and cannot afford a private attorney.
Criminal cases are either felonies or misdemeanors, with felonies being the most serious offenses. If the charge is a felony, the next step is a preliminary hearing, where the prosecutor must present evidence to establish to a judge that there is probable cause to believe that a crime has been committed and that the defendant is guilty of the offense. If the court finds such probable cause, a second charging document, the felony information, is filed charging the defendant with the crime, and a felony arraignment is held where the defendant enters a plea and the court sets dates for a pretrial hearing and the trial.
If the charge is a misdemeanor, there is no preliminary hearing, and the case goes directly from arraignment to the pretrial hearing. At the pretrial hearing, the parties may discuss settlement of the case and make motions, such as discovery motions or a motion to suppress evidence.
At the trial, the prosecution is required to present evidence and bears the burden of proving that the defendant is guilty beyond a reasonable doubt. The defendant does not have to prove anything, but may present witnesses and other evidence. At trial, the defendant has the right to a jury. After hearing the evidence, the jurors are the sole and exclusive judges of the facts. The judge instructs the jury on the law that is to be applied in deciding the case.
If the defendant is found guilty, the next stage is a sentencing hearing, where the prosecution and the defense can present witnesses and advocate for what they believe is the appropriate sentence. After hearing the arguments, the judge sentences the defendant.
At any stage in the proceedings, a defendant may decide to plead guilty or no contest, in which case the court will sentence the defendant.